Good, sir.
Okay.
All right, everybody, I'm going to go ahead and get started. We are just at 9 o'clock, so it is time to start. Just to introduce myself, my name is Chen. I am one of the partners here at this firm that's hosting at Tracy Regli. I have been here since 2015, and I have been in this area, I've been in this firm since 2015. I've been an attorney since 2009. So I've been doing this for a little bit, even though I am just starting to get my gray hairs. Just a little bit of background. I am a Cal alumni, so go Bears. I'm sporting my Cal colors today, my Cal tie. I went to Loyola Law School, graduated in '09, and I started working in insurance law and in criminal law. So I was working with bail bonds and working for a national surety company. So if you ever need a bail agent, please let me know. I am connected to plenty of them, but hopefully you never need those services. Other than that, I didn't like criminal law, I didn't like insurance law, I didn't like any of that. So decided to move up to the Bay Area and then transition areas of law in 2014, 2015. I've been here since that time and have moved up from being an associate here to now being a partner at the firm. I served in a lot of the local area kind of trust in the states groups and things like that. I do actively serve at my church and speak Mandarin, so this is some random background about me. Today's going to be a fairly broad overview about trust administration. This is designed to speak to people who don't know almost anything about this area. And I will tell you how this series came about. If, for those of you who were here last week for my partner Tracy speaking, we came up with the concept of the series very quickly, and that's because we had a lot of new staff come on it. We realized we need to train our new staff on what we're doing. And we're like, hey, why not throw this out to everybody else? So everybody gets a chance to learn. So I'm glad that the rest of you have joined us. You'll see scattered in the audience, there is a handful of our staff as well. So if you would like to meet them, they can introduce themselves there. All right, so we're going to start with kind of a broad overview. We're going to start with what are the goals of trust administration, go through some trust terminology. I'm going to talk through an initial client meeting. So what are things that we're looking at, what are we hearing from them, and things that I'm thinking about at that point. That's not going to go through the details of kind of the day-to-day, but we're then going to go into the details of the day-to-day. What do we need to draft? What do we need to produce for our clients? How are they going to use them? And then lastly, how do we finalize distribution of area like that? So this is kind of your broad. That's not great.
Alex, is it possible to try talking without the microphone? They're just saying it sounds really echoey.
It is echoey. Is this any better on the Zoom?
Alex, that's much better.
Thank you. That is our other paralegal, Sarah Galley, on the line. Apparently figure out by her voice.
Thank you, Sarah.
You're welcome.
All right, so we're going through kind of the broad, that's the broad overline there. And my clicker has decided to stop working as well. All right, so the broad goals of trust administration, the concept is fairly simple. You have a trust document that lays out a lot of terms on what's supposed to happen. A lot of people create a trust to largely avoid probate. That's really the main purpose of a normal revocable living trust. And that's what most people have heard of. There are advanced trusts, which will deal with estate taxes and things like that. We're not getting into those today because that's not necessarily your day-to-day. The normal clientele our firm deals with is your kind of single asset. You own a home, you have a brokerage account, and that's it. You're somewhere between 1 million and $7-8 million. That's kind of our normal clientele. So that's what we're working with today. For the purposes of those trusts, the main goal is to avoid probate, largely because probate, so that's what we talked about last week, right? And the main reason to avoid it, costs, time, privacy, those are kind of your main reasons. A trust is not necessarily simple, but the concept once you've created the document is fairly simple. There's this document that lays out the plan. This is what's going to happen. These are your rights as a trustee. These are your rights as the settlors or the people who created the trust. And then you move forward with that and you carry out the plan. After somebody has passed away, or after both of the creators of the trust have passed away, you're then in trust administration. That's really the process that we're talking through today. So after People have passed away. The broad goal here, marshal of the assets. That really means you collect everything under the umbrella of the trust. Oftentimes there's assets held in random people's individual names. It's held in the trust, but it's under the old trustee. So you need to transfer the assets over, things like that. You have to pay off all the debts. We'll talk a little bit more in detail about that. That's not quite as cut and clear as that, but that's the general goal, pay off whatever debts that are owed by the trust. Liquidate the assets if you need to do so. Sometimes beneficiaries want to receive stocks or want to receive real property in kind, and that's okay. We can deal with that. Generally, most people want cash. So you end up selling a lot of assets and with a pot full of cash. Lastly, you distribute assets according to the terms of the trust. So whatever the trust says, that is the duty of the trustee. The trustee will occasionally come and say, I want to do something else. That's not their job. Their job is to follow what's on the paper. Just a general timeline of what trust administration looks like. This may be a little bit small for you guys. I'm mostly starting from the date of death, right? So from the date of death, you have usually between 0 to 2 months, people will call and then say, hey, somebody's passed away. What do we do? So that's where we start with our trust administration. I will say at our firm, we have experienced people calling as people are dying from the hospital and things like that. It's very unpleasant to deal with, but sometimes people are very urgent to get to the money, so it happens. So just kind of a heads up on things like that. So between 0 to 2 months, people contact you, you meet with your client, and then if they decide to sign on as a client, you move forward to drafting and executing the trust administration documents. That's a lot of what we're going to be talking about today. So what are the documents that we draft? What do we need to help our trustee out? Once we've produced the documents, they have their tools. They have their tools to move forward and to carry out their job as the trustee. So they go and they marshal the assets, they liquidate assets, they pay off the debts, all the things I just talked about. Then somewhere between usually 120 days from the trustee notice, which I will talk about, and 1 year from date of death, that's usually when distribution will happen. There's certainly exceptions to that. If the family gets along, distribution can happen quicker. If there's 7 or 8 pieces of real property, sometimes it takes much longer to sell that, so it could take longer than a year to distribute. There are benefits in terms of taxes to finishing within a year. I'm not going to get into the details of that, but that's why that 1 year cap is usually there. There's tax benefits and there's limits on specific gifts where you have to pay interest if you go over that. So those are kind of short reasons for why a year is your landmark.
Question.
Yeah.
You said the trustee will come to you. Is that the trustee that is not experienced in managing trust, or is that all trustees need to go to an attorney, commit to handle their requirements after they set this up?
Sure. And for those of you online, were you able to hear the question? Sarah, I'm mostly looking at you.
It was a little hard to hear. If you could repeat, that'd be great.
Okay. I just want to know if I generally have to repeat the question. The answer is yes. The question here is, do all trustees need to hire an attorney? The answer to that is no. I say that most people come to us largely because our firm has been doing estate planning for a very long time. Frank Acuna, our senior partner, has been doing this for 30-something odd years. So we have a lot of estate planning clients who, after their parents pass away, the children come to us because they're familiar with us and give us a call. If you're new to this, that may not happen directly for you, but generally it's non-professional trustees who are calling. So lay people, family members, things like that. There is an industry called professional fiduciaries. They do exactly what their title sounds like. They handle these things for a living. There's an organization, we're a part of that organization and things like that. But they will occasionally seek representation if they feel like they need it. So that will happen as well. That's largely if there's complications in the trust for some reason or another. Mm-hmm. All right, so I'm going to go over some basic terminology just so you guys, and I'm going to be using these throughout, so just so you understand what I'm talking about. Okay, so a trustor, a trustor, a settlor, or a grantor, those are all the same thing. These are the people who initially created the trust. So if you have a husband and wife creating a trust, those are your settlors. If you have a single person creating a trust, that is your trustor or settlor, whatever you want to call that. Your trustee is a person who is in charge of the trust. So similarly to how Tracy talked last week about an executor or an administrator, same concept here, except they are in charge of the trust instead of in charge of a probate. Beneficiary, these are people who are entitled to receive assets from the trust as a distribution. So there's going to be grouped into a couple different categories. There's an income beneficiary, a remainder beneficiary, and a contingent beneficiary. I'm going to briefly go over those. An income beneficiary is usually during the seller's lifetimes. They are entitled to receive the income from the trust. That's because if I create my own trust and I put my funds in there, I want to be able to spend my money how I normally spend it. So I'm entitled to receive all income. I'm entitled to spend all the money in the trust. That's the concept there. A remainder beneficiary is somebody, it's kind of what it sounds like. It's people who receive the assets at the end of the day, whatever's left goes to these people. Contingent beneficiary, there's conditions, right? There's conditions on when they receive assets. So it could be, I leave assets to my children, but if they are predeceased, then it goes to my dog. My dog would then be a contingent beneficiary at that point. I'm going to use may versus shall for those of you who are in law school or who have done other things in law. You probably know the difference on this. May is optional, shall is not. A lot of times in a trust, there will be language that will differentiate which path you should go. Sometimes it's optional, sometimes it's not. Issue, most people think of as their kids or their descendants. That's kind of the direct line. So my issue currently is I have one daughter. That is my issue. If she had children of her own, then they would potentially also be considered my issue. So just descendants, that's really what to think about there. Specific gifts, we mentioned beneficiaries before. This is a form of a beneficiary, but a specific gift is specifically carved out. It's exactly what it sounds like. It's specific. So Holly here is going to receive $5,000 in cash. That is a specific gift. My wife is going to receive the house. That is a specific gift, as opposed to the whole pot is going to be called the residue, which is right after that, right? So how it works is you have a pot of money in the trust, take things out. Those are the specific gifts that come out on top. Whatever's left is then called the residue. Real property, most of you should know this, it's land, right? Land or structures or houses, things like that. Personal properties, anything that is not real property and that is not cash or investments, right? So my watch is personal property, furniture, personal property, knickknacks, Christmas ornaments, whatever, those are all considered personal property. A pour over will, Tracy probably talked about wills last week. A pour over will is a specific type of will that works with a trust. The idea behind it is it catches whatever is left out of the trust on accident and pours it over into the trust. So what the will says is, I want my assets to go to my trust, right? So the idea, again, pour it right back into the trust. Intestate, Tracy talked about this last week, means dying without a will or a trust. Estate is anything held in an individual's name, and that does have to go through the probate process. Well, generally, we'll talk a little bit about that. But that is largely what we're trying to avoid today, is having an estate. Any questions regarding just basic terminology? And I failed to introduce this at the beginning, so Sarah, I forgot. If you are here, you have not signed in, please do so. You can do so after the session, or if you want to get up in the middle, I'm perfectly fine with that. I do work best with interruptions. I like questions. So if you have questions in between, just raise up your hand and I will answer them as we go. Did I forget anything, sir?
No, thank you guys.
All right, so this is our basic situation. For those of you who are on Zoom, you should have the handouts. I'm not going to read through all of this. Those of you here have it in your exhibit, have it in your slides as well. But this is the basic situation we're going to talk about today. We're going to look at it briefly now. I'm going to come back to this at the very end after we've talked about all your tools, and then we can talk about how do we deal with each of these situations. So just briefly, S1 and S2, that stands for spouse 1 and spouse 2. C1 and C2 stands for children. Let's see, a disclaimer trust, I did not talk about it, and you don't specifically need to know that for today. It's a complication within a married couple trust in which you don't have to do anything after one spouse passes away. That's a general concept. And then we are meeting with child 1, who happens to be the trustee. Child 1 also happens to want to keep the primary residence. So we'll talk a little bit about that. There are a couple different terms in the trust. There's some specific gifts, right? So you have real property going to friend 1 and friend 2. Very nice person to give away real property. And also we have ultimately the residue to the children in equal shares. That's fairly normal within the trust, so you'll see that pretty often. Okay. And then these are the list of their assets. They own real property, 1, 2, and 3. You'll notice that specific gifts gave out real property 4, and that is not here. There's a mobile home. So everybody's favorite to deal with. These are very difficult. We'll briefly address this. We're not going to go into the details of that. There's a brokerage account worth about 1.5 million, checking account titled as spouse 2 and child 1, and we'll talk about how to deal with that. There's a savings account titled in just the name of spouse 2. There's a car, 50 shares of Chevron stock, which I use as an example because we're fairly close to San Ramon. We get a lot of clients with a lot of Chevron stock. Then there I specifically mentioned computer share. That's a very difficult company to work with. I'll talk about that a little bit as well. There's an IRA, and then there's a safe deposit box. Okay, so any questions regarding the assets? All right, so what am I thinking in terms of assessment and issue spotting here? Okay. So number one, what was the date of death? That's going to be huge because that will start off a lot of our timelines. By default, you notice the first thing I pointed out there is a creditor statute, which I'll talk a little bit more about later. Basically, under civil codes, you have 1 year from date of death to file any claims against a decedent. So, right, so that's a hard cap. There's notice statutes given by the California Probate Code. That's what CPC stands for. 16061.7, which we'll talk about a little bit more later as well. Read the trust. The trust document is your guideline for what should happen during trust administration. Right? So who is your trustee? Are you talking to the right person if you're looking to represent the trustee? So child 2 approaches you, they're not the trustee. Well, if your goal is not to represent a trustee, then they're not the right person. If you're looking to litigate potentially against the trustee, that might be the right person to talk to. What type of trust are you working with, right? We talked about the revocable trust. We talked about kind of the advanced estate planning trust. So what are you dealing with? Who are the beneficiaries? Who are the parties involved? Are there specific gifts? Kind of read through the document. The bypass split I briefly talked about with disclaimer trust. I'm not going to get into the details of that, but that is something I'm thinking about. Is there a step that was missed in between or anything like that? Does the trustee have a duty to pay off all debts? That'll come in the creditor section. Do the trustee fees, can they be paid for their job? Some trusts say no, most trusts say yes. And most trusts say, quote, reasonable compensation. What does reasonable mean? Accountings, we'll talk about that. Are we talking about a California trust? If we're not, I'm kicking away the client immediately because we can't deal with non-California law. So they'll go to whatever state this is venued in. And then is there anything weird, right? Unusual situations, that may be vague right now. If they tell you, my mom gave everything to the dog and decided to not leave anything to the kids, that's a little bit weird, right? So just things like that will trigger you as, hey, this is not normal. Again, what assets are we working with? That's not in the trust, but that's a conversation with your client and with the trustee. What is in the trust? What are you dealing with? How many pieces of real property? What are the assets? And then finally, background and family issues. Tracy, my partner, likes to talk about how probate and trust in the estates is often family law, but just involving money and involving right? There's all kinds of family fights will come up. Mom always loved you more. Mom always gave you more. Dad always liked daughter the most. And those fights will come out and trigger things within the trust administration, right? So kind of relationships make a big difference here. All right, so our assumptions, just because this is a 101 class, everything's normal. Absolutely everything is normal, okay? That is nice. All right, so I'm going to jump over now into kind of the tools of what we're working with, right? And number one is the death certificate. For those of you who are flipping through the PDF of the exhibits or who have it in person, it is exhibit 1. And this was pulled online. So this is the death certificate of Michael Jackson. I'm not going to have it up on the screen because it's kind of a pain to bounce back and forth. But Michael Jackson died in Los Angeles, right? So you get to see what it all looks like. An original death certificate usually comes in on this pinkish, purple, bluish piece of paper that has a specific kind of weight to it as well. but it lays out a lot of the details that we need to work with. What's their date of death? What's their social security number? Things like that. That will give us information to work with. Where you can get it, if you need it, if your client doesn't have it, wherever the person passed away, that county should have, the county of residence. At the recorder's office, you can obtain a copy. Only certain people can get it. As an attorney for a child or an attorney for a trustee, you are a person entitled to get it. I mean, the goal of this is so not everybody can just pick up a random death certificate. Informational copies, like this one is for Michael Jackson, anybody can get, right? So that is available. Alternatively, the Department of Vital Records in California, I have the website link there. Death certificates are also available from them. I believe you can online order. I think they're $40 now. One of my staff members can probably correct me, but I think $40 is now the cost. Again, pretty much everybody's going to need a death certificate. What I mean by that, for each piece of real property, if you're recording documents, you're going to need that. If you go to the bank, they're going to want to see a copy. Most banks will kind of take a copy, take the original, make a copy of it themselves, and then give you back the original. Some banks will keep it. We need to send it to our legal department, so on and so forth. Usually 10 or so copies is sufficient, but you can always go back and order more. All right, lodging the will. Tracy probably talked a little bit about this last week. I'm not going to get into this in whole detail. Here's the statute, which I'm not going to read to you. What it basically says is, if you have the original will, you have a duty to lodge it. Remember, we talked about the core of a will, how that will usually come with a trust and part of your full estate plan. That is still a will. So if you have the original, it does need to be lodged with the court. Lodging for practical purposes just means you bring it to the courthouse, you tell them you're lodging a will, you pay $50, they keep the original, and you get a copy back that says lodged on the top. The concept is wills are public documents, right? So the public has a right to see them. They want to go in and check the records, they can. All right, notices, and these are fairly significant, so I want to kind of focus a little bit here. The first one we're going to talk about is one called a trustee's notice. The trustee, and again, the concept of a trust is that here it is, the trustee is an open book to the beneficiaries, right? They are in control of everything, but they don't have a right to hide information. The beneficiaries have a right to see exactly what's going on. So that's mostly the purpose of this first notice. And the statute here is California Probate Code 16061.7. Again, I'm not going to read statutes to you. I'm just going to explain what they basically say. The concept, sorry, you had a question?
You mentioned the beneficiaries have the right to all the activities of the trustee. What about the residual beneficiaries?
The residuary beneficiaries are the main people that have a right to see it.
So
And sorry, the question for those of you online is, who are the beneficiaries who are entitled to essentially see the trustee's actions?
even if they're in a case where you have two settlers, one dies, one of the settlers becomes the trustee and they bring in another trustee.
So the question is, what if one spouse, there's two spouses, one spouse has died, the other spouse is still surviving? Who has rights there? The quick answer is the surviving spouse and the income beneficiary at that point is the only person with the right. However, that's kind of beyond the scope of what we're talking about today. We're really talking about two deaths. I'm happy to talk to you afterwards about that. Any other questions there? All right, so what this notice basically says is we're going to send out a copy of the trust, let people know who the acting trustees are, and sorry, the statute actually does not require you to send a copy of the trust. We do it as a firm because we don't like to hide things, but you don't technically have to. You send them a notice that says, this is the acting trustee. This trust is now irrevocable because both people have now passed away, or because the only settler has passed away. So beneficiaries, you now have a right to get notice of this trust. There's a paragraph in bold and caps, which you see at the bottom here, the you may not bring an action to contest the trust. That's essentially a no contest provision. So you're telling the beneficiaries, you have a limit of 120 days to contest the trust if you want to do so. What a lot of people think a trust contest means is if the trustee does anything I disagree with, then and I complain about it, then I'm not going to receive anything. And that's not right. What a no contest clause does is it talks about whether the underlying trust document is valid or not. right? So if somebody is going to contest the trust, they have to file a court action that alleges that the trust document is invalid because of fraud, undue influence, something like that, essentially saying that this document should not have existed in the first place. If they lose on that action, then they're correct. They would not inherit anything from the trust. However, they win on their action, then the document's knocked out, right? The document no longer exists. There's only a single trust. You're potentially back to a probate. So that is kind of the result of a trust contest. If you think about the situation on a broader scope, if you have a child who's completely disinherited, they have all the incentive in the world to contest the trust, because they would not receive anything if they didn't contest. And if they do contest, they do have a chance, right? So there's a lot of assets, and the child's been disinherited. You often do see trust contests in those periods, in those situations. The most significant thing about this notice is that 120-day clock, right? Because when they receive the notice is when that 120-day clock starts rolling. The law does allow for, usually, I believe it's 5 days of mailing, so it's not technically 120, it's usually like 125. Notice to creditors, right? So we talked a little bit about a trustee paying off debts, and I kind of had a question mark there. And I'm going to talk through that a little bit, right? So the Civil Code gives you a 1-year default for when a lawsuit can be brought against the decedent. That 1 year is a hard statute of limitations firm. You know, there's no exceptions to that. So it's a pretty good backstop to use. However, you look at the probate code, 19001, and it talks about on the death, the trust assets can essentially be used to satisfy the debts of the estate, right? So essentially, if the settler died, had debts, the trust can be used to pay it off. There's a series of cases, the Dollar versus Arluck series, which basically talked about how the trustee has no duty to hold on to trust assets while there are pending claims in a probate estate. So what happened in this case was the creditor sued the estate and established a judgment. In the meantime, the trustee had completed trust distribution. All the assets were gone. So when the creditor turned around and sued the trust to collect the assets, trustee said, sorry, we have nothing left. We can't pay you. So what the court ruled is they had no duty to hold on to those assets. So the trustee was safe. What it did not say was the beneficiaries are still liable for whatever those debts were. So they receive those assets, they can still go after the beneficiaries. From a creditor perspective, that's very disincentivizing to have to figure out who the beneficiaries are and have to sue maybe all 20 people. But that's what the recourse of the creditor now is, right? So because of that lack of duty, I now have a question of, should I have the trustee pay off the debts, right? It kind of opens up that question, because if they don't and they distribute the assets, what rights do the creditors have? Sure. Sure.
The 60 days notice. So I guess I'm confused about that. Is that 120 days?
And where?
The 120 days, that's the timeline period, but the 60 days, is that?
So yeah.
They have 60 days.
So again, yeah, so the question is, the statute on the 16061.7 talks about a 60 days within the trust contest provision. So, and kind of what does that mean? That's kind of the underlying question. So the 60 days addresses a situation where the trustee sends out this notice, but does not provide a copy of the trust, right? So I mentioned my firm as a practice sends out a copy of the trust just so we get the full 120 days rolling. So it's possible you send out the terms of the trust, and then 90 days down, somebody comes in and says, I now want a copy of the trust, right? I have this notice, but I want to see exactly what we're dealing with. You send out the trust now, they now have 60 days from that time period. So you've extended the 120 now out to 150. Does that make sense?
Right, but do they have less, like if you serve it?
If you served it with your initial notice, then no, you're at the 120 days.
Gotcha.
All right, so jumping back to the creditors, I talked about Dobler v. Arluck and talked about the question of what we're dealing with. So again, the assets of a trust are available to pay for a creditor's claim. That's kind of what that 19001 talked about. But what does the trust say? Some trusts give the trustee discretion whether to pay the debts or not. Some trusts say the trustee shall pay the debts of the decedent, in which case I think it's fairly clear. the trustee has a duty to pay it, so you go ahead and have them pay off all the debts. If the trust, and some trusts say you can't pay the debts of the estate, that's fairly rare. What most trusts that I've seen say is the trustee the trustee may pay the debts of the estate. So you end up with this kind of ambiguous situation. Well, which statute are you going to follow? I'm going to then come back to this in just a second, right? And I'm going to skip over to a notice to creditors and talk about that and how this all interacts. So 19003 of the probate code then talks about a notice to creditors. What this basically is a filing in the Superior Court, then a publishing in a legal publication. Similar to a publication of a probate, the idea is you put the world on notice that this person has now passed away, right? So any person who has any debts has to then file their claims within 120 days, right? So the main benefit from the trustee's perspectives is you've cut this 1 year statute of limitations down to 120 days. However, it comes at a couple of costs. Number one, couple $100, publishing fees, things like that. Number two, and probably more major, is you've opened up a direct pathway for creditors to attach claims to the trust. Originally, what they would have to do, because you can't, normally it's a person who owes money, right? So if you open a credit card, it's not in the name of your trust. So the debt's against the estate. For creditors to get to the trust, they have to first file a lawsuit. They have to first open a probate. They have to establish a claim in the probate. They have to win that claim. They then have to turn around and sue the trust, then win that judgment before you finally have something you can collect on, right? So multiple steps, multiple hoops to jump through. What the notice to creditors does within the trust context is it now opens up a direct pathway for creditors to get to the trust assets, right? So all those hoops, gone. In my opinion, that is not worth it. That opinion differs even across our firm. So Tracy last week likes to do more notice to creditors than I do. She thinks the 120 days is better. You're better off cutting that time period down as opposed to waiting out the 1 year. So it's somewhat a risk analysis, right? And it's really for your client to decide, but for you to understand and to explain to them, these are your potential risks on either side. I do want to briefly mention that some of the largest creditor claims that we've ever seen that actually go through the hoops are employment law creditor claims for care providers that have been providing care and have been paid under the table. The main reason for that is employment law claims are very strict in terms of wages, in terms of overtime pay, in terms of breaks and things like that. And it's fairly strict liability. You know, I don't practice in that area, but I've dealt with multiple suits that have each been over $1 million. So just in the sense that these can be very large claims. Yeah, so ultimately on creditors, open question, right? On what's the path that makes the most sense. For me, what makes the most sense for the most part is to leave everything to the 1 year statute. I don't file a notice to creditors often, if at all. The only time I will largely consider it is if I know there may be an employment lawsuit coming, then it may be worth it, right? You shorten their time period, but then you're also giving them potentially notice that they have a right, because you do have a duty to send out the notice to known creditors, right? All right, so we're going to jump into the physical documents that we're going to be working with. The trust certification, your statutes here, basic concept, you have a shortened version of the trust that tells banks what your rights are, what the trustee's rights are, and who is in charge of all of this. They'll usually have on it tax ID number for the trust as well, which we'll talk about a little bit more later. I will give kind of just the basic practice pointer of banks don't like to use other people's forms. Banks like to see their own forms. What most banks do is your trustee brings in the trust certification, they'll request a copy of the trust. They aren't entitled to that, but they will still request it and oftentimes will refuse to open an account unless you give them a copy of the trust. It's up to your client on how much they want to argue with the banks. When I created my trust, I personally argued with the bank because I'm like, hey, I practice in this area. I don't want to give up my privacy, so on and so forth. It cost me about an hour and a half of my time, right? So it's whether that's worth it or not, the trustee. But the banks will usually make you fill out their own version of a trust certification anyway, because they like to see their own forms, their own documents. So that's a warning I give my clients. Yes, you have this document, you're going to have to fill out the exact same information anyway, but it gives you all your information in the same spot. And again, I have a sample in the materials. You can take a look at what that looks like. The statute lays out, essentially what it says. And sorry, as we go, the examples for what these all look like are in your materials. So I provided copies of what our firm uses for each of these. All right, taxes. Everybody, if you haven't noticed already, trust administration is dealing with all sorts of areas of law, right? You deal with real estate, you deal with taxes, you're dealing with probate, things like that. So what happens with a tax ID number is a person's trust normally reports on their social security numbers during their lifetime, right? So a revocable living trust, mine reports on my social security number and my wife's social security number. After both of us pass away, well, our social security numbers die with us. So what happens then? Right, so we need a new tax ID number to be able to report any tax transactions after the death of the settlor. Right, so there is a easy online application to complete. I believe I have a link right there to the website that's on the IRS website. There's a lot of links out there that'll say, pay us $40 and we'll get you a tax ID number. What they're doing is just, they have you complete the same forms we're doing. It's a free service. The IRS provides it directly. Clients will be fooled by this all the time. Just, be aware that this is sitting out there. The form SS4 is in your materials. That's a authorization for a third party to obtain a tax ID number. Your trustee, if they obtain it themselves, they are not a third party, so they don't need that form. However, you as either their attorney or as their paralegal, as some of our staff does, obtain that tax ID number for them, you are a third party because you're not the person who actually needs that. You're just representing that person. Right, so the SS4 authorizes you to obtain that. And I'm trying to find it in the materials. Exhibit 4. Okay. Yeah, so it's under Exhibit 4, the SS4. You'll see it's a fairly simple application. A couple things to note on it, just if you're actually going through it. Responsible party under 7A. A responsible party is the grantor of the settlers of the trust. There are instructions to the SS4 if you look up on the IRS website that tell you that. But what a lot of people will confuse that for is that's the trustee, and that's not right. That's going to be the person who initially created the trust. And that will be their social security number under 7B. Then under 9A, it talks about the TIN of the grantor. That's going to be the same thing. That's going to be the social security number of the person who created the trust. Yeah, question?
So this is for third party, for the trustee, how, if they were to go to an EIN, is there a different problem?
It's the exact same process. If you go through the online application, essentially there's a portion that asks, are you a third party, like third party obtaining an EIN? If you click yes, then it brings you through answering the questions that are essentially on the SS4. And then it tells you, you need to have this completed and signed by the person who's actually, you're getting it for. So for our purposes, we're mostly keeping this in our records. We occasionally have needed to fax it in case the IRS can't get the number online for whatever reason. But it's mostly a CYA form for us. Yes, we do actually have authorization. Yeah. And sorry, for those of you online, the question was essentially what happens when a trustee themselves try to obtain an SS4. And to, I guess, directly answer that, they don't have to answer all the questions when you go through the online application. They can still obtain the number themselves. Let me. I'm trying to decide whether I want to talk about taxes now. I'm going to briefly mention it, and I'll probably come back to this at the end. Usually, the trustee is going to be responsible for at least 2 different tax returns. Number 1 is the personal final tax return for the decedent. Right. So if mom passed away in July of 2023, you have 7 months of activity in 2023 that you potentially have to file taxes for while they were alive. You're also going to have a second tax return for the trust. So for this new tax ID number that you just pulled, there's a tax filing that has to go with that. This is not your traditional 1040. So most individuals file on the 1040, right? You do TurboTax or whatever. That's fairly straightforward if you want to go that route. As a professional, I pretty much recommend that you should always hire a tax professional. People listen to me on occasion, but it doesn't always happen, especially for the personal. For fiduciary tax return, I do specifically tell them I would do this because TurboTax doesn't necessarily cover it well. Even a lot of tax professionals don't cover it well. That's because there's a lot of deductions that go into it. that are not part of your normal 1040. For example, in your final year of trust administration, legal fees are a deduction. But does a normal tax professional who doesn't do these returns know that? Not necessarily. I'm not going to get into the details of taxes because that's a whole kind of different session. Just know that there are complications there. Check with your tax professional, make sure that they have experiences with 1041s. All right, so I already briefly talked about this part on this slide. My recommendation, just go for it. Depends on how much you care. I'm kind of particular about stuff like that, so I went the other route. That's up to you guys. All right, so the next tools that we're dealing with are deeds. So again, different areas of law, we're now talking about real estate. What this statute basically says is if a person passes away and ownership is owned by, and the real property is owned by a trustee of a trust, you can do an affidavit of death that essentially takes them off that deed and puts in a new trustee. That's the concept. You tell people that the person holding title at that point has passed away. It does specify there that you can use a court order as well. We're not going to get into that today. There are cases where we use court orders. And then from the Board of Equalization, it talks about how the method of transferring property, right? So a grantor may make a gift of property to the grantee for the purposes of a trust, the individual to the trustee, right? That's your grantor and then your grantee. You may use a grant deed or a quitclaim deed for the purposes of a transfer or for a gift deed. Grantor may, but may not say in the deed, kind of because of love and affection. This will take place after you're actually making distributions of real property. We would use a gift deed for that purpose, right? And that's what this is talking about.
Oh, the affidavit of death is for two.
No, the affidavit of death is for a situation, usually when you're just starting out. So dad has just passed away. That's the last surviving spouse. Child one now comes in as a trustee. Your dad's still on title. So title's currently held as dad as trustee of the sample trust, right? So if the child one goes to sell the property, what the title company is going to see is, hey, dad's still on title. He needs to be the one to sell this. What the affidavit of death does is it tells the recorder's office, dad has passed away. There is now a successor trustee, and the person with the right to sell is now child one as the trustee. Does that make sense?
Now, if they're not selling, you don't have to do the affidavit.
So the question is really regarding affidavits of death and how they work. So I answered the first half of that. The follow-up question was, what happens if they are not selling the property? You still, and the answer to that is the affidavit of death would still need to be done because dad is no longer alive, right? So even if you're following a chain of title and you're doing a gift deed after this, right? So let's just say specific gift, which we'll talk about later, specific gift of property to child two. Dad, as trustee, holds the property. If child one does a deed that then says this property is gifted to child two, there's a break at the chain of title, right? Because you have dad who's no longer alive who can't do it. Now child two stepping in, so you have a title issue there. So what the affidavit death does is it puts on title who now has the rights to transact.
Okay.
Does that make sense?
Yeah, I have a question. That's okay.
Okay.
Would you file that in addition to the form that the Berkeley County Clerk has, or is that?
The question is, do you file the affidavit in addition to the form the recorder's office have? And I have a question for you, is what form are you talking about?
It's on the notification.
The note, the trustee's notice?
I can't remember word for word what it's called, but the county recorder has a form that you can fill out to notify the death.
I believe what you are talking about, there's a question regarding what forms the recorder's office have. I believe what you're talking about is the assessor's office has a form called a change in ownership, death of real property owner, which I will talk about in just a second. That is different.
Oh, okay.
Yeah, so deeds go to the recorder's office. The assessor is going to deal with real property taxes, which I will address in a second.
Okay.
Yeah, recorders are simply dealing with chain of title, who has the right to transact on the property. Any other questions there? All right. So moving forward to gift deeds, these are largely only used if people are keeping the real property. I'll get to that in a little bit at the very end, actually. But the concept is then you're gifting it from the trustee from the trust to an individual or to somebody else's trust. And there are a couple of different forms that come along with this that are required. Number one form is called a PCOR, or preliminary change in ownership report. That is in your samples. I've lost track of my exhibits. It is exhibit 8. But you can see kind of basically what it looks like. What it's basically doing is telling the recorder's office, what type of deed am I recording with you here? In my opinion, it's kind of a silly form because you're recording a deed and telling them what you just recorded. They have it, they can just read it, but they don't do that. So what we usually will put on here is we're just substituting a trustee, at least for the purposes of the affidavit of death, or for a gift deed, there's a transfer from parent to child exemption and things like that. You would read through in part 1, there's transfer information. You essentially read through and which one of these apply. And so you would have to figure that out. For the most part with trust, it's going, for our purposes, it's usually C or, where is it, K? Yeah, for K. However, if you've just created a trust, if you're on the estate planning side of it, maybe you're looking at L. This is a transfer for a revocable or into a revocable trust, right? So you need to read through and figure out what you're working with there. For the most part, for these transactions, there are no transfer taxes. So if you look at page 2 of this, that's largely why they're asking these questions. Is, do you need to pay on this transfer? Do we get to collect money? For the most part, for our deeds, the answer is no. If you're selling a property, yes, there is transfer taxes. We don't deal with those forms directly, at least not with our office. The escrow companies, title companies will usually deal with that. The second form, sorry, I'm still on the same slide, is the change in ownership report. And this one now goes to the assessor's office. So again, I briefly mentioned assessor's office and the recorder's office, they deal with different things. The assessor is now dealing with property taxes. And yep, my next slide is I'm going to get into it now. Next slide deals with property tax reassessments, Prop 19. I'm going to go over this fairly briefly because it's kind of in depth, but I'm going to give you a broad overview of it. Prior to 2021, property taxes were handled under the old Prop 13 and Prop 58. Prop 13, this is only California law, right? So Prop 13 talked about how property taxes can at most go up 2% every year, right? So what that, from a broader perspective, what that really did is put an artificial cap on how high property taxes could go. That affects our school systems because our property taxes largely pay to our school districts. So it's just kind of interesting to see, right? In areas with more expensive houses, you tend to get districts with more money, right? That's just, it's how the property taxes work out. What Prop 58 did was an exemption to property tax reassessment. So what the baseline was when somebody passes away or where there's a change in ownership, property taxes get reassessed. So what that means is I own this property, I bought it in 1984 for $100,000. It is now 2024, it's now worth $1 million, right? So because of the 2% cap, my property taxes have only gone up to the assessed value of let's say $150,000 over the years. So the actual property tax I'm paying on that is 1% roughly of that assessed number. So I'm paying what, $1,500 a year. However, upon my passing, there's a change in ownership. My daughter now owns this property. So it's going to get reassessed at fair market value, $1 million. Property taxes are going to jump up to 1% of that number. So you're looking at all of a sudden $10,000 a year instead of $1,500 a year. So a huge increase. And for properties that have been held a long time, that makes a very big difference. Prop 58 was an exemption for properties passing from parent to child. And this will still apply for a death before, I believe it's like February 21st, 2021 or something like that. It's actually on the form itself, the date, but these old rules will still apply. But the exemption was a principal residence with no limitations can be passed from a parent to child, no reassessment, right? So huge. Number 2 was any other real property with total assessed value under $1 million would also not get reassessed from parent to child. Okay, so pretty broad exemption for people who have owned property and kind of built up real estate empires. That's how those all got passed down to kids with very little consequence. They could keep those. What Prop 19 did in 2021 was it changed that exemption. The only exemption remaining is you can pass from a parent to a child, principal residence. So number one has to be a principal residence of the parent and is going to become the principal residence of a child or is already a principal residence, right? So parent lives there, child is going to move in or already lives there. That's your only exemption. Everything else gets reassessed to current fair market value. Just as some background, Prop 19 was sponsored by the California Realtors Association, right? You can probably understand why it put a lot of properties back on the market since these real estate empires are now, 15, 20 times more expensive from property taxes. So going back to my form, that basically goes over the assessment exclusions, but I started on this from, where did I start on this from? The change in ownership report. The change in ownership, sorry, question.
Yeah, so after that change in ownership, and let's say it does get reassessed because they're not gonna make it their primary residence. That child doesn't then have to pay the capital gains incurred by the parent for all those years, right? That will also.
The question is what happens on the income tax side and the capital gains consequences on the transition of a property. I will get into that more at the end, but the underlying answer is you get a step up in cost basis. So generally, no, you would not have to pay capital gains. Yeah. So with the change in ownership report, again, what this basically does is report the underlying debt. So for the purposes of your client, this kicks off the reassessment process. Most of the assessors in our local Bay Area counties are fairly behind on processing their claims and the change in ownership reports. We've had anywhere between 6 months and a year before the reassessment and the property tax bill actually comes in. So for your trustee purposes, if they're going to distribute early, they want to hold back enough money to pay those taxes. I also briefly mentioned here county-specific forms, and you'll see some examples in your exhibits. They're largely dealing with transfer taxes and whether there's a transfer tax owed. So Solano County has a form, San Francisco County has a form, and those are just things to be aware of and to look for. It looks like we may have a question online.
Under Prop 19, does it have to be a principal residence of the parent that transferred to the child, or can it be a duplex or other such property that becomes a primary residence of the child?
Okay, so I think those of you online probably heard that, but just to briefly repeat, what if it's not just a house? What if it's a duplex or there's other units involved, right? That's the basic question.
I think it's, if it's not the principal resident of the parent, can a different one transfer to a child under that property tax?
So the question is, if it is not the principal residence, can it still transfer? It can still transfer, but you're gonna get reassessed.
Even if it becomes the primary residence of the
Yes.
child?
It has to qualify for both. It has to be the principal residence of the parent and the principal residence of the child. It's not an or. There is a situation with duplexes and things like that, or if you have multi-unit things, only the unit where the parent occupied can be transferred. So if you have an apartment building, parent lived in one unit, you save that one unit and that is it. The whole other parts of the building gets reassessed. Any other questions on property taxes before I kind of move forward?
Sure.
All right, looks like we're good there. For those of you following online, I am jumping through the slides because I essentially talked about this without looking at the slides. My practical pointer there is just what I talked about. It's file your claim early because it takes a long time to process.
I had a quick question.
Sure.
On Prop 19, there is a limit still, even the principal residence, everything over $1 million is still reassessed.
Yeah, and the question is there still a cap on Prop 19 at $1 million? And the answer is yes, there is a cap at $1 million. So meaning if you're transferring a property worth assessed value of over $1 million, right? So from the parent perspective, they have to have purchased it for essentially over $1 million. Yeah. So it doesn't usually the cap hasn't applied, at least in the situations we've worked with. It can apply, but it's fairly rare. All right, so we talked about real property taxes. Now we'll talk about a little bit about real property sales. We briefly mentioned a lot of beneficiaries like to receive cash. So you're oftentimes liquidating the real property. Again, you own several rental homes. You're not going to sell a lot of them because of these property tax issues. So what do you have to do? For the most part, that your trustee selling the property, you're dealing with brokers, you're dealing with real estate agents and things like that. From our perspective, we don't get super involved with the sale. It's the trustee's job to set the price. You know, they have a duty to try to get best value or fair market value. So that's certainly my advice is always put it on the open market. Whatever happens, happens, unless you have consent from all beneficiaries, right? So if you're going to give it to one child at a discounted rate, sure. If everybody agrees to that, not a problem. But if you have one person who disagrees, you have a breach of fiduciary duty potentially. What I mostly do is I'm reviewing the real estate forms and the listing agreement for the most part to make sure that our trustee is listed properly and selling as a trustee. Because a lot of brokers and real estate agents, you know, kind of shocker, don't understand this area of law. So what their listing agreement will sometimes say is trustee as an individual selling this property. Our concern from that perspective is, you know, are they incurring personal liability for the sale when they're acting within a certain fiduciary capacity? So I mentioned a couple of different forms. There's a trust advisory, a representative capacity form, and the listing agreement. Those are what I look for. One of our former associates here, who is also a real estate broker, provided me with the kind of base forms that they use currently. So thank you, Jonathan, if you are listening. I don't know if you are or not, but thank you. But the forms are here. What I mostly want to point you to are what I look at, right? So Exhibit 13 is the listing agreement. If you flip over a couple pages, there's a lot of disclosures and things like that and advisories. I'm skipping to the one that says residential listing agreement. I still see some flipping, so I'm going to wait a second. And what I'm mostly looking for at the top of the page, seller. Who is the seller listed? Right, because your seller can either be the name of the trust, so the sample trust, or it can be child one as trustee of the sample trust. If it says child one, that's not correct, right? That's your child selling as an individual. The listing price and things like that, I don't really get into. There's a whole conversation about, is this going to change, right? I don't know. For now, we're still dealing with this basic format. But if you flip over a couple of pages to the end of that agreement, kind of right above the signatures, there's a section now called entity sellers. An entity seller is exactly what it sounds like. This is a person selling within the context of an entity. A trust is an entity for this purpose. And there's even a part there that says in number 4, if a trust identifies seller as a trustee, right? So really in 3 right above that, you would need to check off the box for entity seller. The name of the legally authorized signer is your trustee. And then you would need the full name of the trust under 5. Whenever your client signs the document, they should be signing as their name, comma, trustee, right? That keeps them in their capacity of a trustee. If you flip over a couple of other pages, there's a representative capacity signature disclosure. This form is needed if that entity seller box is not checked off. And actually, if you read the entity seller box, it tells you exactly that. The representative capacity form is not needed if this box is checked off. So, it says it right on the form. Again, the purpose of this form is exactly what that entity seller portion does. It indicates that your trustee is selling within a representative capacity, so as a trustee. Then the last thing I look for is a trust advisory, which I actually don't see attached, which is okay. But what it basically does is it limits the disclosures that a trustee has to give. And this is fairly significant from a liability perspective. Because a trustee doesn't usually live in the house that is being sold, right? It's their parents' house, it's a rental house, it's whatever. And they're stepping into this brand new, they have very limited disclosures they have to give. So they really only have to disclose, I believe, whether there's a water heater strapped in, whether there's a death in the property, and whether there's smoke and carbon monoxide detectors. Those are like the only things they have to disclose. I believe lead-based paint might be one of them too, but very limited disclosures. What a lot of real estate agents will tell your client is to get best value, you have to do a lot of inspections, disclose what the situation, you may have to remedy these things, you have to fix things up, blah, 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 right? Because their goal is price. You as an attorney, you're looking at the perspective of, well, what's their liability? What are the potential problems? If they decide to go down the route of repairing things, breaking open a wall, we're going to remodel this. if they find issues and they then have actual knowledge, they then have a duty to disclose those actual issues. Right, so my advice to most of my clients is don't do any fixes, don't do any inspections. Any buyer is going to want to figure that stuff out for themselves. They'll pay for their own inspection, so why pay for them up front? If they find issues, negotiate on price. So you don't do the fix yourself, right? So just for the example, if you find mold, mold's not easy to deal with, right? So what if the remediation goes wrong? Mold pops up after the fact. As a seller, you may have a duty to have to come back and fix that again. Let the buyers hire their own people, they do their own work, that liability is gone. Right. So my advice is don't do anything, give very limited disclosures, don't do your inspections, and then just negotiate on price if you have to. The problem, of course, is you're going to get probably a lower price if the property's been in fairly rough shape, which is true of a lot of properties I've been held on to for a long time. Ultimately, it's your client's decision, right? So I tell them you're going to hear different advice. You're going to hear advice to get the highest price, so on and so forth. It's their job to figure that out and to make that decision. Yeah, a question online?
What are the liabilities of the trustee when knowingly hiring unlicensed workers to repair the house before selling? What is the duty on disclosure to buyer?
So the question is, what is the liability if you hire an unlicensed contractor essentially to do work? It's the same liability as any other seller. And frankly, that's not my area of the law, so I can't tell you the exact damages or things like that, but it's no different if you hire somebody who's unlicensed, right? If they do something wrong, you may be personally liable for their work. Another question?
Quick question, I talked to somebody, he's a trustee, the other day, and he was saying that he didn't do any of the forms, like the affidavit, death, anything like that, because he's having construction done on the house, and he wants to keep it from being reassessed until they can finish the construction and then sell the property, and the realtor saying, oh yeah, you don't have to change. Is it common?
So the question is, I'm going to reframe this a little bit. The question is, client doesn't want to complete the forms because they think that they won't have to pay on anything if they don't complete the forms, right? That's the underlying question. Number one, they're wrong. Whenever you file the forms is when you're going to have to start paying. So it just delays it, that's all. Does it happen often? I rarely get pushback, but there are clients who think that way. It does happen.
Can they still, will the realtor be able to put the house on the market and they can finish the deal without the change and the?
In terms of the question is, can you still complete a sale if you don't complete a lot of the forms? The affidavit of death, some title companies will deal with it directly. So it can potentially, the underlying answer is the form would still need to be done, but it may not be done by you. It could be done by somebody else. Yeah. All the other reports and things like that are mandatory forms. So yeah, they would need to be finished. Let's see. All right, so that's what yeah, that's all I mostly wanted to talk about for real property. Any other questions on sales of real property or anything like that? All right, so I'm going to jump into some other sets of our tools. And this is called a small estate affidavit, also known as a 13100 affidavit. That's a probate code section, or 13101, essentially equivalent. The idea behind this is we're dealing with assets held in an individual's name that would potentially be subject to probate, right? So mom had a bank account that had $75,000 left in it. She didn't want to put it into her trust because she didn't want to go through the hassle of it. It was her main operating account. So, lots of money flowing in and out. When she passed away, there's still $75,000 left. What do we do with that? Does it have to go through probate? Under the small estate affidavit procedure, you essentially complete an affidavit that says the assets in an individual's name go to the successor in interest, which in this case is your trustee. The reason why they are a successor in interest is because you have a pour over will, right? So anything in the estate will follow what the will says. The will says it goes to the trustee. So they're the successor in interest. Sir, I see the question. I'm going to pause in a second after I finish this. So the concept is you're going to collect the assets using this affidavit then into the trust. There is a cap on this. The current number is $184,500. It's a weird number because it started out at $150,000, and then the law says every, I believe it's 2 or 3 years, the number gets adjusted for cost of living, right? So it's it went up to 166, 250, I believe, and then now 184, 500. I think in another year, it's supposed to go up again. The idea is that's the total cap for assets outside of the trust and in an individual name. That does not include IRAs or beneficiary designation accounts, which I'll address at the very end. And Sarah, let's get the question.
What is the penalty for not filing the COS within 150 days from the date of death?
COS.
Change of ownership.
Where's that S come from? Anyway, the question is what's the penalty for not filing the change of ownership statement? I honestly don't know the answer. We don't ever hit that situation because we file it. I think what really just happens is I don't think there's necessarily a penalty, but I think the taxes just come out a lot later. So if you file it 3 years later, you may have 3 years worth of supplemental tax bills to pay. Where there is a penalty is on the parent to child claim. What I didn't address necessarily is you do have to file claims to claim the Prop 19 exclusions, right? So there is a cap on that. They do reassess after 1 year. And if you file it after the 1 year, then they can, essentially, you don't get to go back and claim. So they wouldn't retroactively process it. So you may have to pay extra taxes for that purpose. Any other questions? Yeah.
So the small state affidavits for stuff that's not in trust already, so that personal bank accounts are, they just never funded that.
Correct. What we often find are usually the operating account, whatever the parent was using to pay their normal bills, will be outside of the trust, and that's fairly normal. There's often a lot of times like small stock accounts that will be outside. So they have like, for some reason, MetLife was really big. I don't know much about it, but there's a lot of MetLife stock sitting out there. There'll be like 20 shares, but that was never transferred to the trust. So that a small estate affidavit would deal with something like that too. Any other questions there? This is a very useful tool because otherwise you'd be going to probate for, $50,000 and it's not worth anybody's time or money. So, this is great to kind of bypass that. I give you all the probate code sections. You notice the font gets smaller and smaller. So I am not going to read that for you. What it basically says is what needs to go into the small estate affidavit. It needs to say who the successor in interest is, who has a right to the property, things like that. If you read the code sections, it's directly in there what the affidavit should look like, or we have a sample in your materials as well. Stock transfer companies. So I briefly mentioned Computershare and MetLife. MetLife, for some reason, always goes through Computershare. EQ Shareholders is another similar company. These are stock transfer companies. I think what happened was, and sorry, if anybody has better knowledge on this, please feel free to fill in. My understanding was back in the day when there were paper stocks, and then they transitioned to electronic stocks, these transfer companies came in. They wanted to transition everything to electronic files. So you would present the physical paper to them, and then they would essentially put it in a digital registry. Computershare does this, is probably the main company that does this. EQ Shareholders also does this. But what ended up happening is they have these records that are fairly poorly kept, and then they have a lot of requirements for completing their forms to collect assets. They also require something called a medallion signature. If you've ever dealt with a medallion signature, they're getting harder and harder to get, and they weren't easy to get in the first place. Only financial institutions can give this. And the purpose behind a medallion signatures, they're essentially guaranteeing the money behind it, which, I mean, who would want to do that, right? If you're dealing with this third-party company. For just as a practical pointer, I think I have that there. If your client has a relationship with a bank, that's probably your best place to go. Most banks and branches that I'm finding these days maybe has a single person who can do it, and they're maybe only in 1 or 2 days a week. So, make an appointment, call ahead and things like that to potentially get that. I've had clients kind of just end up giving up on the asset because they can't get the signature. The forms are particularly in your set because this comes up a lot, right? So the forms are fairly straightforward. They have a affidavit of domicile in there, which, really you're just swearing that they live in California. And you're stating the number of shares that need to be transferred. Most times I've dealt with this, they are held in an individual's name, and you also need to provide a small estate affidavit. The way to figure that out, look at the statement, right? The statement will tell you the ownership. If it's in the trust, it'll be addressed to, Bob as trustee of the sample trust. Any questions on that? Yeah, I'm getting into more miscellaneous stuff at this point. The stock transfer companies, DMV forms, most cars don't ever get retitled into the name of the trust. That's fairly normal. I will say from an estate planning perspective, if your client has very expensive cars, you may want to consider that because, there's a cap of 184,500. You buy a, Tesla Model S or Rivian or something like that, you're, $100,000 roughly. So, maybe you start considering that. Do you need to retitle your car? But the way to transition that, the DMV is very helpful. What's even more helpful is if your client is a AAA member, because AAA has DMV services that bypasses your hour-and-a-half DMV line wherever you go. There's a couple different forms you would need. You would usually need to get a duplicate title if you can't find the pink slip. So there's a form for that. There's also a form called a Reg 5, REG-5, which is essentially the equivalent of a small estate affidavit, but through the DMV. These are all available online, so you can kind of Google it and it pops up. My advice to my clients, if you have AAA, go to AAA. Otherwise, make an appointment. It's going to take you a long time. You do need to transfer title essentially before you could sell it. So that's that's usually why they have to do it. Mobile home transfers, there's a couple of different ways mobile homes are titled. The one is through the DMV. So that would transfer like a vehicle. That's the same transfer. Or they're registered through the Department of Housing and Community Development. I don't really know what that department does other than mobile homes, but for the purposes of the transfer, they have a whole set of forms you have to go through there. So that's just to direct you to where to find the forms if you needed to do that. Question?
Does the 184,500 include all assets outside of the trust? Or can you use the small estate affidavit on a per account basis? Example, stock account equals 75,000, the CompuShare account greater than or equal to 125,000.
The question is the small estate affidavit cap for a grand total or is it for each individual account? It is a grand total. So if you have 5 accounts, all worth $50,000, you are stuck in a probate. That is by law. I will say, if your client happens to show up with a bunch of small estate affidavits to 5 different banks, does anybody really know? Probably not. As attorneys, we have to follow what the law says. That is what the law says, right? You have to go through a probate process if you're over that total amount.
For the DMV forms, have you worked with or recommended for clients with high-end vehicles using the DMV transfer on death form to name their trust or specific beneficiary?
The question is, have I recommended to clients to use a DMV form that transfers on death? No, I haven't. I'm not familiar with that form, so I don't know. Any other questions? All right, so safe deposit boxes. This is something that is getting more and more rare, but I do want to address it just because it does pop up on occasion. If there's a safe deposit box, it's usually not the trust listed as the owner, it's usually an individual. There is a law here, I believe I cited under 331 of the California Probate Code. What will happen is your client will go to the bank and say, I want access to the safe deposit box. This person has passed away. Here's the death certificate. They'll say, great, give us letters testamentary or letters of administration. That means they're asking for a probate because that's what you get through that. They're wrong. The banks are wrong. What the probate code allows for is you can access the safe deposit box for 2 conditions. Number 1, you have a key, right? And number 2, you're inventorying the box. So under those situations, you do have the right to see the box. I've had to argue with banks, surprise, surprise. A sample of my letter that I use, I believe, is in the materials as well, essentially citing the code to them and telling them they have risk if they don't follow what the law says. If you don't have the key, it's going to be very difficult. I'm going to tell you that straight up. If you do have the key, the letter will usually work. And what you can generally do is you go in, you're inventorying the box and you're looking for a will. But if the value in there is fairly low, you produce a small estate affidavit. The small estate affidavit can then collect the box. Right, so you use your tools in combination. Beneficiary claim forms. So I briefly addressed assets that are in an individual's name. What I briefly touched upon are IRAs, 401ks, and any beneficiary accounts. I want to delve into that a little bit more. Those are not handled through either the trust or the estate. Any account with a beneficiary designation is a contract by nature with the company that holds that account. So what the contract basically says is this account goes to my named beneficiary upon my passing. So the recommendation from an estate planning perspective is usually to name whoever you want. Most people, child one, child two together as beneficiaries, whatever that looks like. And then they complete their own forms. All the trustee potentially needs to do is to provide a death certificate. The company themselves will then send out claim forms to the named beneficiaries. They complete their own forms, they collect the assets from there. Just from a basic guideline, under the Secure Act a couple years ago, the rules behind this did change a little bit. A beneficiary or a beneficiary receiving, it's called an inherited IRA for obvious reasons, you're inheriting it. But you have up to 10 years to withdraw the money in whatever increments you want, but you do pay the taxes as you withdraw the money. So you can wait until the very end, pay it all in one lump sum, whatever you wanted to do. There are exceptions to that, which I'm not going to get into. The old rule was you could stretch it out over the lifetime of the oldest child. So you could essentially take smaller increments. The change in the law was largely designed to get more money into the economy. Yeah, life insurance annuities are very similar. They're all beneficiary designated, so those all pass by the same way. Corporate documents, I just want to briefly address this. If there's like a family-owned LLC, you own shares in a small company, essentially. You will need to potentially review the operating agreement to see what happens with these shares and how they transfer. Some agreements have limitations on who they can go to. Most agreements have a provision that say upon a death, you can transfer it to the kids, or there's a duty if you have to sell it back to the other owners and things like that. It gets a little bit into kind of the corporate area of law. So you need to understand that or refer your client out to a corporate attorney who does know what to do with that. A notice to propose action. Again, these are just miscellaneous at this point, so not related. Things above. I cite the probate code. I just briefly mentioned this. A notice to propose action, I think Tracy talked about last week within the context of a probate. You give notice to propose action. Beneficiaries have 15 days to object. Otherwise, they're deemed to have consented. Similar concept within the trust, except it's 45 days, right? So the notice period goes up. We very rarely do this because from a practical perspective, if you're kind of concerned that there may be objections, we may as well go to court and get approval anyway. So we kind of rarely do this. For a probate, you have to do it. For the sale of real property, that's why they come up a lot more. I would potentially do a notice to propose action for something like, the trust doesn't say this, but I'm going to give a car to grandchild 3. Because it's worth very little value. Mom always wanted me to give it to that person, even though it's not in the trust. Yeah, you're taking away money from everybody else, right? So you want them to sign off or to be okay with it. But does it really matter? Maybe not. So you give this notice, here 45 days, okay, you're safe.
Question?
Yeah.
What if the notice is only part of the deal? And you say, what do you mean? So they go to the court for the approval to sell property. Property is in partnership. Court grants it, what the court doesn't see, it's an amendment to the partnership agreement. It says upon the transfer of more than a certain amount of shares, the other partners become silent partners.
I'm going to cut off the question a bit because it is beyond the scope of what we're talking about. The basic premise of the question was, what if the trustee gives notice, but it doesn't give full disclosures on potentially corporate liability? Let's put it that way. Does that properly summarize? The trustee's under duty to disclose, right? Again, trustee's an open book. So if they don't disclose, they're under the same obligations of the contract that they're under. They are operating, they are the owners of these shares. They have the same obligations to the corporation. Yeah. Court actions. I briefly bring this up because there is an ability to go to court to get things authorized by the court. This is mostly from a liability perspective. And if you're doing things that are kind of not necessarily directly stated by the trust, or you need clarification, what do these trust terms mean? We're dealing with a trust right now that, we talk about the residue being the pot of the trust. Well, the trust only gives out 50% of the trust. What do we do with the other 50%? Right, so that's a question. So you can go to court for under 17-200. That's a petition for instructions. trust in the states is very broad in your ability to go to court. So this is kind of an open book to just say, we need instructions for X, Y, and Z because something's unclear, right? So you want the court authority, and you can say, you've already given notice to all beneficiaries, so they've had their chance to object if the court approves it. There's also, if you need to go to court and there's no trustee, you potentially need to go under 15,600, which is another kind of window into the court to say, hey, there's no current trustee, we need somebody appointed. So those are potential abilities to go to court. Any questions on that? And I am at about 10 minutes. I might run a little bit over. If you need to go, I'm not offended if you just disappeared. So please feel free to do that. So I'm going to jump into then finalizing and distribution. So a couple of things will come up here. Income taxes, I already briefly touched upon earlier regarding what you need to file. I do want to address the capital gains question, which came up as well. So for income taxes, for the purposes of what taxes you'll have to pay, usually fairly limited. And the reason for this is because of step up in cost basis upon deaths. So generally speaking, upon the death of a parent, the children are going to receive assets at the date of death valuation. And it's called a step up in basis, meaning you're going to receive it at that date of death value, as opposed to what they paid for it at the beginning when they first purchased it. Just as an example, I'm going to use Apple stock. And let's just say I purchased Apple stock for $100 a share. I sell them for $150 a share. My capital gains tax is $150, my sales price, minus $100, my cost basis or my purchase price, for a capital gain of $50. My tax that I pay is you multiply that by whatever your capital gains tax rate is, 15 to 20%, something like that. And you pay that number to the IRS. What a step up in basis means is, let's just say I've now passed away. My daughter is going to collect this asset. I purchased at 100. It was worth 150 at my date of death, and she's selling it for $200. So instead of 200 minus 100 and paying the taxes on that 100 difference, you get it at a value of 150 by date of death value, right? So you only pay on that $50 capital gains, a much smaller number usually. I will say a step up in cost basis also goes along with a step down in cost basis. If your assets have depreciated, you do have to take that step down as well. So for the purposes of a house, that can be fairly significant, right? We talked about our example, purchased for $100,000, now worth $1 million. You receive it at the $1 million mark, so you don't pay capital gains on the $900,000 increase between that time period. That is a absolutely huge benefit to most people. But any questions on cost basis and step ups? I will say for the most part, you don't have to know this stuff. If you don't know the answer, talk to your tax professional, right? That's what they're there for. They're there to explain these things. Sorry, question?
For the appraisal of the real property value, especially if it's like, a year or two ago, maybe, what's the official form that the court wants to see for that?
So the question is, what if the death was a couple years ago? How do you establish your value? I'm rephrasing your question a little bit. The court doesn't actually take a look at this. It's usually the IRS that's dealing with the taxes, but what you would want to get is a formal appraisal. So there are people who do this for a living. They're just called appraisers, right? You go ahead and pay one, it'll cost you a couple $100. You get a date of death valuation, and they'll give you a packet that's probably about 30 pages thick. It tells you the value of the property as of the date of death. The IRS presumes zero gain or loss if you sell the property within 6 months of date of death. So this is really applicable if you're going to be longer than that. Most tax professionals I have worked with are comfortable stretching that 6 months up to a year. Anything outside of that, I would strongly recommend getting a formal appraisal. What your clients will come in and ask is, well, what if I just get a broker's opinion? I don't have to pay for that. They can do that, and it may work, but the IRS does not have to accept that to establish valuation. So I briefly talked about those things, date of death statements. All right, social security numbers for your beneficiaries. Usually we send out W-9 forms. This is a request for taxpayer information. So what it is I want your social security number because I need to issue a tax form for whatever reason. Beneficiaries usually don't object to this. I've never had I've had a problem with it once, but it's usually not an issue. The purpose for this is usually for your trustee when they file their taxes for a trust. You're generally going to send out a form called a K-1. Again, this is getting into more detail than you really need to know. K1 form essentially says the trust is not going to pay taxes itself. I'm going to send, as a trustee, send the taxes out to all of the beneficiaries to pay on their individual tax returns. The reason for that, trusts pay taxes at the highest tax bracket at, I think, $600 of income, which is pretty much nothing, right? So you're already at your, I believe it's what, 36% tax bracket, whatever that is. While most individuals are not in that highest tax bracket. So if you have more income, you send it out to the beneficiaries, it's an overall tax savings. That's kind of the concept behind that. But again, final year of trust administration, you can only do that in the final year. Oh, and sorry, you need to actually get the W-9 form to send out the K-1s because you need to know where it's going. And when I say you, I mean the trustee. Estate taxes, this only comes up with estates that are worth more than the estate tax limit, which currently is roughly $12 million per person. Again, we don't deal with this very often. Our normal clientele is between your 1 and 7 and 8. If you happen to have a very large estate, this is just a flag. Hey, you may want to think about filing an estate tax return. Estate taxes are if you die with money more than that amount, there's like a 40% tax rate. So if you own 20 million, $12 million estate tax limit, you're paying 40% on 8 million. There's a lot more detail to that, which I'm not going to get into today. Except for something to keep in mind is the estate tax is set to sunset in 2020, at the end of 2025. So 2026, the number is not set yet. The general consensus is it's probably going to be around $5 to $6 million, but it will depend on who's in office at that time. Republicans like this number to go up. Democrats like this number to go down. Biden had a proposal to drop it to $2 million and never went anywhere, but it gives you a sense of kind of what they were thinking. And did you have a question?
What do you tell clients about that now? Because sometimes when you're kind of close to the line, say you're in up to $7 million range, right? So anyone basically over 5, you gotta be a little worried.
Yeah, and the question is, what do I advise clients if they're getting fairly close to the limit? My advice is if they're close to the limit, talk to a tax professional and probably file the return. Even if you're under it, it's worth letting the IRS know that you are under it. There is something called portability. If there's 2 spouses and you're looking at the first debt, potentially you want to claim that portability as well. That's essentially you can combine the exemptions for spouses to reach a grand total of roughly 24 million. Right. Yeah, question.
Is it odd or is it something that might be more common than I think to not have to file for personal income tax returns, but having to file a trust tax return?
The question is it common to not have to file personal, but still have to file the trust tax return? I wouldn't say it's common, but it happens. A lot of older people don't have very much income, so there may not be a need to file that final personal, but the trust is going to at least want to consult with a tax professional to see if they have to file it. Right. You want, ultimately from a trustee perspective, you want other people to tell you what's right and wrong, right, for protection purposes. Yeah.
What do you do if you have a beneficiary who does not have a social security number? Can they still get their share or their?
The question is, what if you have a beneficiary without a social security number? That's usually if there's going to be a foreign beneficiary, that would be the scenario. They can still receive it, but they may have to apply for a taxpayer ID number. Yeah. There are foreign taxes and stuff like that involved, which is beyond the scope. Yeah.
I mean, if they're foreign, then you'll have them fill out a W-8 EEN, and they provide the foreign taxpayer ID number, which is usually catches almost all foreign taxpayers. So there's a form either way.
Thank you, Holly. Holly's answer here for the question is there is a form W-8, which is essentially the equivalent but of a W-9, but for foreign beneficiaries. All right. Where am I on time? I'm already at time. I have maybe about another 10 minutes or so. So bear with me if you like. If you don't, feel free to go. So finalizing and distribution. Specific gifts, we already talked about, they come out on top. So I'm not going to delve into that too much. If a gift is no longer in the estate, it disappears. Right? There may be conditions on that gift saying if child 1 is already dead and doesn't receive this gift, it goes to friend Z, whatever that may be. Those conditions could still apply, but if the whole provision lapses and all people are dead, that gift just goes away and it falls into the residue. Residuary gift, again, everything that's left over. Generally for finalizing, a couple things to think about. Trustee fees. Most trusts, again, I mentioned this before, state reasonable fees. That's usually determined by the county, wherever the administration is. Contra Costa County is roughly 1% of the trust assets per year. Alameda County is right around there, maybe a little bit below. Solano County, also about the same. 1% is a good rough number, but it does go up and down a bit. In terms of hourly rate, it can also adjust as well. I'm going to hold questions, get through the slides, and then finish. Other things to think about, a reserve, right? So I mentioned trailing costs like the property taxes, the supplemental property tax bill, things like that. There may be trailing bills that come in. You know, a reserve is always a good idea. You hold back a number that the trustee is going to hold and not distribute out to the beneficiaries. Main reason being, if a bill comes in after the fact, it's much harder to get money back from beneficiaries when you've already given it out to them. And accounting, again, this is very significant. I'm not going to get into today. This goes back to the concept of your trustee as an open book. And accounting is a glorified check register. It tracks every cent that moves around within the trust. And by default, beneficiaries are entitled, residuary beneficiaries are entitled to an accounting. They do have the right to waive it for families that trust each other and that trust the trustee. Most of our clients opt to waive an accounting because it takes more time and it costs more money. It's essentially the equivalent of providing all the bank statements to every person, right? You can see exactly what's happened. Taxes, I already had talked about that. Other options for securing protection for your trustee. So we talked about the accounting, how it's needed, things like that. You can send out the accounting with a check and wait out the statute of limitations. Statute of limitations on this is 3 years for beneficiaries to object to an accounting. That's a long time to wait, right? So we don't like to do that. Trust can limit that down to as low as 180 days. It's probably about 50-50 on trust that I've seen on trust that limit it or not. So 3 years is fairly normal. So is 180 days. So are trusts that say 90 days, but the law doesn't allow for that. So if it says anything less than 180, it defaults up to the 180. You can also go to court for approval of your accounting. So under that petition for instructions, 17-200, that is an ability to get that. I will say Alameda County does not allow for these petitions unless there is a controversy and somebody objects. I don't think that is proper, but they do that anyway, and we don't really have a recourse. So just to be aware, you know, we will sometimes choose to file things in Contra Costa and pull venue into Contra Costa so that we can actually file something in court. Finally, a trust distribution agreement. I give you a probate code section here that basically says that you cannot condition a distribution on signing of an agreement. However, nothing keeps you from seeking a voluntary release. What our trust distribution agreement is, and it's in your sample, it's basically telling beneficiaries, we're presenting this to you as an option to sign this agreement so that you can receive the distribution and we don't have to go to court to get it approved. It's going to save you time and money. The agreement really just says that the beneficiaries are going to sign off on liability. They accept that this is what they're going to get, and we're done, right? That's the concept behind it. Can we actually do this under the law? Kind of an open question. You know, are we asking for a voluntary release? If you look at our cover letter, it does specifically say this is voluntary. You don't have to do it. We have I know attorneys that approach it from a very different way, that you have to, that the beneficiary has to volunteer and give you the release before you ask for it. We have never had anybody object or contest a trust distribution agreement. We use it because we think it saves time and money for everybody. And usually people get along well enough for it to work. If they're already not getting along, we're going to court anyway, right? So we use this as kind of a side option. Ultimately, for you to decide, do you think this is right or wrong? You know, we choose to use it. So just briefly running through the sample trust, right? Again, this was our situation. I'm going to deal with all the assets. I'm going to skip ahead to a couple slides. All right, so we had real property 1, the personal residence worth $1.5 million. This is part of the residue. There was no specific gift for it. Client 1 wants to keep it. Okay, great. Long-term holding. We want to get an appraisal, right? So we talked about capital gains tax. That's something to think about there. What do we need to do to collect it? Affidavit of death, if a P-Corp, change in ownership. Those are your initial real property documents to collect the assets into our client's control as a trustee, then to give it to himself as a giftee. You still have to do a P-Corp that goes with every deed, but the giftee would put it into his or her individual name. They now own the property. The claim for reassessment exclusion, again, this may apply depending on whether it's going to be a principal residence or not of the child. Real property 2, worth $500,000. Again, not a specific gift here, so it's part of the residue. Same affidavit of death. If you're going to gift it to somebody, a gift deed, otherwise you're selling it, dealing with the real estate documents. Real property 3, it was a specific gift to child 1. So we're just doing an affidavit of death, change in ownership, P Corp, then a gift deed in P Corp. Because this is not a principal residence, no exception. So no other property tax forms to fill out. The mobile home worth $200,000. DMV or the Department of Housing and Community Development forms, then you're going to sell it. Most people don't want to keep a mobile home, but if they do, they can certainly do another transfer to themselves or to whoever that person is. Your brokerage account worth roughly $1.5 million. You need your trust certification, right? The shortened version of the trust to get the trustee's name on title there so that they can control that asset. If you're keeping it, you would potentially want a dated death statement from the brokerage company. They do provide these that will establish your cost basis. They do kind of automatically step up your cost basis if they know there's a debt. If you're going to sell it, then you go ahead and sell it and you realize the tax consequences at that point. Your checking account titled as spouse 2 and child 1 worth $25,000. I didn't address this while I was talking. Joint accounts by law go to the surviving person on the account. So here, spouse 2 just died. This is technically child 1's account. That's a presumption by law. However, that presumption can be overcome if you can show that it's meant for convenience only. It was really meant to be part of the trust, so on and so forth. So that's from a court perspective. What we tell our clients is if this was mom or dad's money, put it back into the trust, right? Don't keep it for yourselves. If it was meant to go to you, sure, that's your money. Checking account. I just talked about that. Savings account. Title and name of spouse 2 worth $50,000. It's in their individual name. Small estate affidavit, right? We talked about that. You put together that small estate affidavit, you bring in a death certificate to the bank, you can get control of that asset. That will then be deposited into your trust account. Car worth $5,000. We talked about the Reg 5 form and how to collect that. Your Chevron stock held a computer share, held in the name of spouse 2. We're looking at a couple different things. Small estate affidavit, you complete their forms with a medallion signature, and a death certificate will usually get that done. There also happens to be an IRA worth $500,000. Child 1, child 2 are the named beneficiaries. They each complete their own forms, so they go ahead and collect that. Your safe deposit box, I already talked about that. Try to work with the bank nicely. If they don't work nicely with you, you do have the option to go to court. Try to hold them in contempt. I've never had to go to court, but the threat of it usually does the job. So other distribution issues you saw before, there was a specific gift, right? Child 2 was getting property 4. That property no longer exists. That gift doesn't go to them. They lose out. That happens all the time. Properties move around, people sell things, that gifts lapse all the time. I didn't talk about the second section. I'm not going to because I'm already past time. Any other questions? And because I am at the end. Yeah, question.
We're talking about shares. You can't give the value of the shares like at the date of trust. You have to do an actual appraisal.
The question is, how do you get the valuation, the date of death valuation of stock shares? That's usually, you're correct, it is the date of death valuation, and it is whatever that number is going to be, but you'll want the financial institution to provide that for you. Right? There's no appraisal, there's nothing behind it, but they will essentially give you a new statement that shows the date of death values. Any other questions? All right, thank you guys for your time. For those of you who are signed up for all 3 parts, I will be speaking next week on conservatorships. That will be a whole different kind of animal to deal with, less financial, more personal. I personally love conservatorships because it very much affects people individually and it helps protect people who need it. So, that's a fun concept, but also a very difficult concept. So hopefully see you guys next week. If not, have a good day.
Thank you, Alex.
Now my clicker works. I never came back, so, right?
Yeah.
I never used it.